Joe Biden and Kamala Harris have vowed to take away your Second Amendment rights through gun bans, gun confiscation, and government regulations. Now, Joe Biden is no longer hiding his real intentions, and we need you to take action now.
Whether it's a 9mm pistol or whether it's a rifle is ridiculous. I'm continuing to push to eliminate the sale of those things. But
the Biden administration is coming after your right to own any gun. Joe Biden has already issued executive orders.
And welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every Friday, Alex Ulli of the Ulli Law Offices in Indiana. Alex, thanks for coming by again today, man.
And no problem. Thanks for having me, Paul. Great to be with you.
What we wanted to talk about today was the history of the Second Amendment, but before we get to that, some late-breaking news today that I wanted to ask you about a little bit, and that is, it appears that and to start off with, as I've mentioned before on the show, we do not ever give out names of mass killers on any airwaves I'm associated with, and we will not repeat the names of the killer, the name of the killer here. So, but the parents of the person accused of killing several people in the Michigan shooting apparently are being brought up on charges in Michigan. Obviously, they weren't there at the school pulling the trigger, but they've been there. Let me pull up the story here, and we don't need to see the pop-up ad there, but they're being brought up on, it looks like, accessory charges. How do they get how do they get charged in something like this, man?
Yeah, so the shooter himself, it looks like is being charged with murder, but the parents, like you said, they weren't the ones doing the actual killing themselves. So it's interesting that they're being charged here, but they're being charged with, it looks like, involuntary manslaughter rather than murder, which means there's not a clear definition and it varies state to state, but it means basically that they were very negligent, or reckless with respect to their child, which resulted in these murders. And I don't know enough of the facts, but it sounds like the killer got the firearm from his parents. And I think the parents had purchased the firearm on a Black Friday deal, and the child got the firearm just a few days before he did the killing. So it's interesting. I don't know exactly what the theory is that the prosecutor will be presenting, but the breaking news is that they are going to be charged, it sounds like.
And just briefly perusing the article before we went to air, we had like literally 2 minutes before we went to air to look over the article, and it looked like from the article they were facing let's see here, count of terrorism causing death, 4 counts of first-degree murder, 7 counts of assault with intent to murder, and 12 counts of possession of a firearm and the commission of a felony. That's what the killer is being charged with. He faces up to life in prison without parole if convicted. And I'm trying to get down to what they're being charged with.
I believe it's 4 counts of involuntary manslaughter, which doesn't require, unlike most crimes, doesn't require any intent. So if it's voluntary manslaughter or murder, obviously that requires intent to kill the person. But with involuntary, it doesn't require intent. It simply requires criminal negligence. And that's what the prosecutor is going to have to come up with, some theory of criminal negligence here.
Meaning they knew that there was a possibility somebody could die by their action or inaction, right?
Right, right.
Okay.
basically a reckless disregard of harm.
Okay.
So,
Interesting.
yeah, it's interesting. You don't see this sort of thing often. Sometimes you see it in the civil context where maybe someone a gun to someone else and trusts them with a firearm, and then that person goes out and uses it. But that's generally not the person who loans the firearm is generally not held liable because unless there are some facts that would give them reason to believe that that person would use it for harmful purposes, they're generally not going to be held liable. So it'll be interesting to see what the facts are in this situation to present a case against the parents.
Yeah. I want to get to a couple different, real quick, I want to get to a couple different comments here, and then we are going to get to our topic that we'd planned because I don't want this to be the second time we go to this topic and we never get to it. But Mike says on the YouTube side, Mike says you're responsible for your own kids. I think, when I was growing up, if I was throwing a baseball and somehow that baseball went through a neighbor's window, guess what? My dad had to pay for that neighbor's window. If somehow a minor child of mine were to get a hold of one of my firearms and go to a school, am I not financially liable for what my kid does?
Yeah, I mean, I think there's a good argument for that, and I think that's what the prosecutors are going to try to show here is that not only were the parents negligent, they were so negligent, they were so grossly negligent that not only are they civilly liable, like for monetary damages, like you're talking about, which requires a lower degree of negligence, but they're so negligent that they're potentially criminally liable, so that their freedom can be taken away, not just their money.
Okay. Charles over on the Facebook side says that Academy Sports has stopped selling 30-round magazines in North Carolina. If that's true, man, that's on Academy. That's not a great sign. And it is not illegal in North Carolina to be buying 30-round mags. I would be going either to other stores that sell them, or I would be going to Drury's or House of Guns or Drury's House of Guns or anywhere else on the internet and buying all you could.
It's interesting. I think the
ahead.
Second Amendment Foundation has of companies that have taken anti-gun positions, and I don't recall exactly where that list is posted, but basically the insinuation is, hey, if you can do business somewhere other than these places, do it, because these businesses are against your individual right to keep and bear arms.
It is up on the SAF.org website. I don't see it at first glance. I will find it. I'll get it on the comments on both YouTube and on Facebook here before long. But I've got to get a couple more comments in just here real quick because I want to get off to the topic we wanted to do. But John said also the parents purchased the SIG as a gift for their son. Here's where the danger is, man. I don't want the gifting ability to go away. For those of you who notice there's something new in the background of my image, my wife got me a Christmas present today. I don't want that to go away. I don't want the ability for my wife to go buy something and give it to that and then give it to me as a Christmas present. I want to be able to, if I want to, I want to be able to go down to the gun store and buy something for my wife and give it to her as a Christmas present, or my son who happens to be of age to own. if I want to buy my son a rifle or a handgun or whatever, I want to retain that ability. That's where universal background checks would kill us all. That I don't want that to go away.
Yeah, undoubtedly, this massacre will be used as an opportunity by gun control advocates to try to restrict our rights even more. Unfortunately, whatever restrictions they come up with or propose, I think will only serve to restrict criminals and not law-abiding citizens. Or I'm sorry, I had that reversed. Will only serve to restrict law-abiding citizens and not criminals.
Right.
So I think that's the bad thing.
I promise, 2 more comments, then we're going to get off to our regular topic. Charlie Chambers, this is a great one, man. He says, sorry, but politicians are like sperm. 1 in a million turn out to be an actual human being, attributed to comedian Argus Hamilton. That's great, man. That's awesome. And Mike White, back over to the YouTube side. Mike says, if parents were held responsible, I think kids would behave better. You know what? I think if everybody were held responsible, especially in places like Portland, Oregon, if people were held responsible, I think they would behave better. And yeah, in general, if parents were held responsible for their children's behavior, then they would make their children behave better.
Mm-hmm. Yeah, unfortunately, we live in a world where it's almost frowned upon to hold your child responsible. I mean, there's people out there who I think are hesitant to parent their child or be forceful in a legitimate way with their children to raise decent human beings. So I think it's just one of those ways where society has moved to more dependency on government and less dependency on families and good parenting.
Yeah, absolutely. And I've said this a million times before, but I don't remember saying it recently. So if you think the government, if you think the government can do a good job at anything, I challenge you to name one thing, just one, the government has done without totally screwing it up. And I might give you parts of the military, but I'm going to give you other parts. If you say, well, we haven't been invaded in 200 years, I'm going to give you don't ask, don't tell. So anyway, let's go back to the history of the Second Amendment. We're not going back to the Magna Carta here, are we?
No, we could go back a long way with the history of the Second Amendment and the right to defend yourself. But we're really just going to. I think the goal, like we talked about before we went on air, is really just to give people some context, sort of like the lineage of the Second Amendment, to give some context to this New York State Rifle and Pistol Association case that's at the Supreme Court and awaiting an opinion sometime in the spring. Okay. And so I kind of like to start with the adoption of the Bill of Rights. You know, at the time of the founding, there was this dispute between the Federalists and the Anti-Federalists about what form of government we should have. And the Federalists advocated for a more centralized form of government and the adoption of the Constitution. The Anti-Federalists said, wait, hold up, we just won a war against a king in a very centralized form of government, and we don't want to go down that road again. And they were more satisfied with the form of government under the Articles of Confederation. So as sort of a compromise, the Federalists said, okay, well, let's adopt the Constitution, but we'll enumerate certain things that the government cannot do. And we'll say that these first 10 amendments to the Constitution are going to restrict the government in certain ways and say that those rights not specifically given to the federal government are reserved to the people and to the states. And those first 10 amendments, as we all know, are known as the Bill of Rights. And I think what's important for people to recognize, if you don't already know this, is that the Bill of Rights was meant to apply to the federal government only, not to state government action. So it was really only meant to restrict federal government action, not state governments. So that's what's important to understand. The Second Amendment, when it was adopted, didn't apply to state government action. It only applied to federal government action. And that changed over many years And there was the adoption of the 14th Amendment after the Civil War because there was this worry about individual rights of newly freed slaves and that their rights were being infringed upon. So that was really the first step in what's called incorporation doctrine, where certain portions of the Bill of Rights were said to apply to state government action. So it wasn't like after the adoption of the 14th Amendment, all of the Bill of Rights suddenly applied to the states. The Supreme Court, over many decades, applied the Bill of Rights to the states in part, selectively. And the second wasn't out of the states until 2010. And we'll get to that here in just a little bit. But for many years, there really wasn't much litigation surrounding the Second Amendment because there really weren't any restrictions on the Second Amendment, or very few restrictions anyway. And that remained the case really until the early 1900s. And in 1934, the federal government adopted the National Firearms Act of 1934. That was in response to Valentine's Day, where there was a dispute, a massacre between rival gangs in Chicago, an Irish gang led by Bugs Moran and an Italian gang led by Al Capone. Several people were killed. Some automatic firearms were used in that massacre, and there was public outcry and pressure to restrict certain types of arms. So the federal government adopted the National Firearms Act of 1934 and imposed a $200 tax on certain arms, suppressors, short-barreled rifles, short-barreled shotguns, and automatic firearms.
If I could,
that tax has remained in. Oh, go ahead.
I want to interject something here, just to show you the speed at which the government works. What the thing that brought that on was the St. Valentine's Day Massacre in Chicago. Happened in 1929, and the federal government, in record speed, brought upon the 1934 Federal Firearms Act.
Yeah, exactly. Yeah, that goes to your point earlier about name one thing that the government does well, right?
Right, exactly.
So in 1934, the National Firearms Act was adopted, and that was one of the first restraints on the Second Amendment, on the individual right to keep and bear arms. There was this tax imposed. And in 1938, there was a case about the constitutionality of this National Firearms Act. And that case was United States versus Miller. And in that case, it basically said that certain restrictions, types of arms are okay. And that case was kind of an ambiguous case, but many appellate courts around the country, federal appellate courts around the country, interpreted that case to restrict an individual right and interpreted to say that the Second Amendment doesn't guarantee an individual right. It only guarantees a collective right, that right of the militia. And that was really, there was not much of a challenge to that at the federal level until the 2000s, when there was a case out of the Fifth Circuit in Texas, a case out of Texas in the Fifth Circuit that said, it was an Emerson, called the Emerson case, that said that the Second Amendment does not protect a collective right, it protects an individual right to keep and bear arms. And that was one of the first cases where a federal court said that it was an individual right to bear arms. And subsequently, the Ninth Circuit said, no, it's a collective right. And when you have two federal appellate courts that conflict, that's called a circuit split. And wherever there is a circuit split, the Supreme Court is likely to review that dispute and try to resolve that issue so that we have some consistency with the law and the application of the law across the country. And that's what gave rise to the Heller case, which came down in 2008. And what was interesting about the Heller case was that it was brought in the District of Columbia. And the District of Columbia is a federal enclave. So when the court said that it protected an individual right to keep and bear arms, it didn't say whether or not that action applied to state government actions as a restraint on state government action. It still only applied to federal government action, and as of 2008, the Second Amendment had not been incorporated to apply to the states. And that was until 2010, when, on the heels of the Heller case, the Second Amendment Foundation, by the way, was behind the Heller case and also behind the McDonald case in 2010, where the petitioner challenged restraint to keep arms in Chicago. So we're no longer in a federal enclave, we're in a local government. And they challenged that restriction in Chicago, and that case went to the Supreme Court, and the Supreme Court said, in 2008, we decided that the Second Amendment protected an individual right to keep and bear arms, and now we're saying that the Second Amendment is incorporated to apply to the states. So from 1791, when the Bill of Rights was adopted, until 2010, it was never, the Second Amendment was meant to apply to the state. It's not until 2010 that we get a decision from the Supreme Court that says that the Second Amendment is incorporated to apply to the states through the Due Process Clause of the 14th Amendment.
Yep.
And that's really what brings us to today with the New York State Rifle Litigation versus, because in that case, the petitioner is challenging the may issue licensing scheme there and the special need requirement. So the question is whether that restriction on the right to keep and bear arms is one that violates the Second Amendment, and it's one that can be challenged now because the Second Amendment, as we know from the McDonald case, is meant to apply to state government action.
Yeah. I want to get one comment in here. Actually, I'm going to get two comments in, but I want to get one from Mike White in first. He commented, gun laws were first initiated to stop freed slaves from buying firearms. I'm pretty sure it was just a typo there. I've heard that quite often before, and I've talked to many people, including some pretty prominent podcasters who have made that case quite well. I don't have the history myself to back that up. I don't doubt it in the least, though.
Yeah, Stephen Hallbrook has written some great stuff on this topic. And there's another, let me see if I can find the book real quickly. I think it's Nicholas Johnson is his name, if I'm not mistaken. He wrote a book, and actually he co-authored a law book with Dave Kopel. And he's written some great articles about gun control, some of the first gun control and how it was actually anti-black legislation, basically. So
yeah,
how gun control has racist roots, essentially.
Next comment I want to get to is from Shane over on the Facebook side, talking about one thing government's great at. Well, they're great at communism. How's that? Well, I suppose but here we go with name communism that's worked. You know, there's been a lot of countries that have tried it. Name one successful communist country. And true communism has never been tried. Venezuela did. So, yeah. Yeah.
Well, some people, per your question earlier, Paul, name one good thing that government has done. That people may be able to name some things here and there, but one thing is for certain is that the greatest atrocities ever committed were committed by governments, and generally communist governments.
Yes.
Hundreds of millions of people killed.
And our own government is not, doesn't have absolutely clean hands on that. Just look up Wounded Knee sometime if you think our government's hands clean. They're not.
And I found the book by Nicholas Johnson. It's called Negroes and the Gun, The Black Tradition of Arms. And it's a book, like I said, about the sort of the roots of gun control.
And Charlie Chambers just came through with a comment I want to get up to. He says, well, the pistol permits in North Carolina are directly related to racist Jim Crow laws to keep arms from blacks. Democratic Governor Cooper vetoed the bill passed to end the racist law in North Carolina. You know, honestly, in a lot of states, Illinois is one of them. I don't know how much a carry permit in New York costs, but in states where you they're very restrictive. Average people struggle to make the kind of money that it costs to go through all the the additional training plus the permitting fees plus this and that to get these permits and the time off from work. They got it for all the appointments and the this and that. I mean, they're putting it out of reach for the common person, which is, I mean, let's be honest, people of all color, but disproportionately poor people are generally people in the minority bracket. So.
Mm-hmm. Yeah, and that was an issue raised by the public defenders in the New York State Rifle and Pistol Association case in their amicus brief. So if you're interested in that issue, that brief would be an interesting read. You can find that at SCOTUS blog. It's linked at the SCOTUS blog website.
All right. Well, we are coming down to the bottom of the hour, man. Anything else we should be, as relating to that case, anything else we should be talking about in the history of the Second Amendment?
No, I think that's kind of a whirlwind of the Second Amendment history. There's a lot more to it, of course, but I think that gives people some context. And obviously, we're hopeful with the New York State Rifle and Pistol Association case that it will be favorable to our rights. On the cost of a permit topic, going back to your comments, Paul, I mean, I don't think people should have to pay to exercise an individual right, a constitutional right. That's not what I don't think we'll get that far in the New York State Rifle and Pistol Association case. But I hope we make some progress in that regard and at least take some steps in that direction. So anyway, I hope this conversation was helpful to folks.
My hope is I live long enough to see where all 50 states are what we now call constitutional carry. As long as you are an adult and are allowed, as long as you are not a violent felon, you are allowed to carry, and you don't have to go to the government and say, "Government, may I please?" and here's some money. That's right. My hope. Before I die, we see constitutional carry that is legal everywhere the Constitution is covered. That's my hope.
I agree. And we're making some great progress. There are over, I don't know the exact number, but over 20 states now that have constitutional carry. So
hoping for it now. Oklahoma already has it. Ohio looks like it may get that there by the end of this year. And Louisiana already has it. Alabama looks like it's going to get it shortly after the first of the year. So, yeah, we're two more, and Ohio. Where Ohio excites me is that may tip the scales to where if Ohio gets it, that may be where 50% of the population lives in constitutional carry. Right now, we're not to 50% of the states, but a lot of the states, like South Dakota, my home state, are sparsely populated states. But Texas is a big state, population-wise, and Ohio is a big state, population-wise. Other states that I hope get it, that are making noise, but I don't see going very fast, would be like states like Florida. Arizona's a big state population-wise. They got the 6th biggest city in the nation in Phoenix. So I'm hoping very soon we get to the point where 50% of the population of the United States is in constitutional carry. So
yeah, we've been close in Indiana a few times, but obviously Indiana's not a huge population center. But I hope we take the final stride and get constitutional carry here soon.
Oh, I don't know where you guys rank, but you've got Indianapolis, and you've got, well, Gary, which is kind of the coattail of Chicago there, but you've got some pretty populated areas.
Yeah.
So, all right, and Carol Halverson, if you're still watching, nice try, but I don't respond to trolls on air anymore. My blood pressure medication, I'm trying to get off the blood pressure medication, and my doctor does watch this show from time to time. So, anyway, I think it's a good time to go ahead and set this one aside. We're running just a little bit late. Alex, thanks again for joining me today, man.
Yeah, no problem. Thanks for having me, Paul.
Everybody, come join us at noon Central Time tomorrow for the Weekly Bullet. That's our wrap-up of the events of the week. It's a 1-hour show where we discuss pretty much everything that's happened in the Second Amendment over the week. Until then, thanks for watching, everybody.